will you want to kick us off here?
Absolutely, my pleasure. Good morning, everyone. My name is Lee Stokes, and I am the Vice President of the Northern Operations for Vesta Property Services. So basically, I oversee the Jacksonville, Daytona, Volusia, Flagler, Orlando, Gainesville, and Tampa area. But we're here this morning to present our legislative update, which we do every year. And it was a busy season in Tallahassee, so we have a lot to cover. I won't take up a lot of your time. For those of you that are on the line that are Vesta clients, we thank you for trusting us with your association relationship. And for anyone out there that may not be connected with Vesta, we would welcome the opportunity to chat with you about our services. But I'm going to turn it over to my friend and colleague, Ed Ronsman, who is the expert here with us this morning with McCabe Ronsman, who is a law firm that specializes in condominium and association law and operations. Ed and I have been doing this for a little over 13 years, I think.
Yep.
We try to do at least 3 of these educational seminars a year. And as I said, it was a busy season in Tallahassee, so we have a lot of material to cover. So Ed, I'll let you take it away.
All right. Well, thanks, Lee, and good morning to everyone. I know we have a good number of participants here today, and we thank you all for joining. I'm Ed Ronsman. If you haven't met with me before, this is the only area of law that I practice in, which is representing condos and homeowners associations. And a big part of that is staying up to date on the legislative changes that typically happen each year. We might go a couple of years between, real big substantive changes, which is kind of what's happened in the last couple of years for us. This year, we saw some big changes due to largely in response to COVID, but there have also been a lot of bills and items in the bills that have been kind of simmering in the background that have been attempted to be included in previous legislative sessions that were able to be included. Like anything else, it's not a perfect process. There's a lot of negotiating that goes on, lots of separate bills that are then negotiated to have items included on ones that will survive. Obviously, all of the relevant industries have lobbyists that have their say on it in terms of what the final outcome is. And oftentimes the wording is not perfect. So we always need to bear with that. And a lot of times there are changes that come about. One of them we'll talk about is for term limits for board members for condos, which I feel like this is our third legislative update in probably the last 4 or 5 years where that's been addressed. So you can see kind of how the process goes about. And so we're going to go through the relevant bills that passed. For those of you that I'm sure we're all very Zoom proficient by now, but if you would like to ask a question, I'd love to answer them. There's a Q&A button at the bottom. If you type in there and for any questions that you'd like to have, that way it pops up for me and I can make sure that I answer them. If you can use that instead of the chat function, that would be great. We're recording this right now. I know this is through for Vesta so that if anybody can't attend, so if you have any board members that couldn't make it, I know that we'll be working with Vesta to make sure that the recording is available for you. And then for any of our community association managers that are on here, this is a continuing education unit course, CEU course. So I can work with Vesta to make sure that I can get your license numbers and we can submit this for approval. And that way you can get some legal update credits as well. All right, so I'm going to share my screen. All right. So our 2020-21 legislative update, we're going to start with Senate Bill 630. This was the main bill that had most of the changes that affected community associations from a substantive standpoint. So the first one I wanted to touch on is for condos and for HOAs. And if we have any co-ops in here too, that the co-op statute was amended as well. It clarifies that the statutory emergency powers apply to states of emergency as a result of contagion such as COVID-19. So by way of background, when we had a state of emergency declared last year because of COVID, it allowed the associations to tap into the emergency powers that are in the respective condominium, cooperative, and homeowners association acts. There are, in terms of what the act provided before the amendment, when you read it, it's very clear that it was drafted to cover physical damage to the community property, where people couldn't get to the property. You had to have meetings elsewhere. You needed to have meetings, if you needed to have quick emergency meetings to make decisions because of damage to property, that you could have notice for the meeting in as manner as reasonable as possible, but that it kind of eliminated the minimum 48-hour requirement. But it all really revolved around damage to the property, making decisions, the board making decisions to what was safe for occupancy and that sort of thing. What nobody really had contemplated was a situation where you don't want the common areas to be used. You don't want to have meetings in person because of a pandemic like COVID. Even the DBPR, which is the Department of Business and Professional Regulations, and of that, the Division of Condominiums, Timeshares, and Mobile Homes, last year, they issued a statement basically saying that we interpret the emergency powers to apply in the pandemic. The fact that they had to issue that can tell you that the statute itself didn't cover it in the way that it should have, and has now been amended to be covered. The second point is that it authorizes the boards to conduct board meetings, committee meetings, and this is a big one too, I think, membership meetings and elections in whole or in part by telephone, real-time video conferencing, or similar real-time electronic or video communication. This was a big issue that we had, and one of the main things that I was asked about as an attorney, which was, we don't want to have meetings in person. It's not safe due to, at the time, not having social gathering, 6 feet of social distancing, everything else before we had the vaccine. And so the question was, can we have virtual meetings? And we always felt comfortable in our firm of stating that you could have a virtual board meeting, largely because board members have already had the right to vote remotely and be considered present even when they're not there in person. And because it's a board meeting where it's the board that is actually voting on something, we didn't think that there was anything lost by having it completely virtual, to protect the health, safety, and welfare of both the board members and the membership, because board members have always been able to vote electronically. The issue that we had during the pandemic when there was a state of emergency was whether or not you could have a completely virtual membership meeting or election process. And it kind of, the problem that we had with it was that, yes, you can adopt electronic voting. And a lot of communities decided in the last year or two to do that, largely in response to COVID. But the problem is that you only have, electronic voting is only good for the people that opt in to do it. For anybody else that doesn't opt in, you still have to give them a physical ballot or proxy for them to submit. And then that means that there needs to be a physical location for the meeting. And the reason why is that there's nothing in the statute that gives complete authority for members to attend virtually. It has the electronic voting part, but that's only for people that opt in. And so we stated that, look, if you're going to have your membership meeting or election, what you should do is have a physical location, but put in bold, underline, all caps, whatever you need to on the notice and on the letter to the membership saying, please just send this in advance. We will only have a very limited number of people actually at the meeting so that they can, have a proxy present, if it's the president or the secretary, that's the default proxy holder. And then, maybe a couple people from management or whatever, just to count the ballots. But that way, at least you could go and drop off at the meeting and then go back home and watch on Zoom. But we didn't feel comfortable ever saying that you could have it completely virtual. The reason being is because there's really no process in the statute for having members be present if it's not in person or by proxy. And a proxy means that, yes, that member can't be there, but there still is somebody physically there for them at the meeting. That's what the whole purpose of a proxy is. So this will help with that if there is a state of emergency declared. We're not in that right now. We're all watching the news and seeing what the numbers are like right now. But I'm not sure that we're going to see that in Florida with another state of emergency declared so that we can tap into these powers. So as you're going into your annual meeting season, potentially for some of you, budget season, but annual meetings also a lot of times take place in the fall. Just note that if we're not in a state of emergency, you still need to then go through the normal process for your membership meetings, notice it, but really I would encourage you to look at electronic voting as a way to try to minimize having people in person, because once they electronically vote, they don't really need to go to the meeting and they can just attend via Zoom. Recommend continuing to look at doing that. But this does help if there is something that comes up later, state of emergency is declared, it's because of a pandemic, that you have more flexibility for holding these meetings. It would also allow associations to give meeting notices by electronic transmission too. So continuing with the emergency powers, condominiums may consult with public health officials when determining whether any portions of the property are unavailable for entry or occupancy. Obviously, there's a difference between a condominium and a large single-family residential community just because of the nature of condominium ownership. So in the Condo Act, it says that they may consult with public health officials, but it does state that condos and HOAs may not prohibit owners, guests, tenants, or agents from entering the property during a state of emergency unless it's based on a governmental order or determination or a public health directive from the CDC. So what they're saying is they want to have, if you're going to prevent people from getting to their property, it needs to be based upon some type of a governmental order or from a health directive from the CDC. I don't know if there were some instances that maybe associations just using their own judgment without relying on any directive otherwise, and that maybe caused a problem during the pandemic. That it could be why that was included. But if you are going to prohibit people from going back to the property, we just need to make sure that it's based upon a proper governmental order or a public health directive. All right, so then going into, I'm going to break it down on the Senate bill between condos and for HOAs. For condos, the recall disputes may be filed for arbitration with the DBPR or by court action. Previously, you can only go through the DBPR, which is the Department of Business and Professional Regulations, and they have an arbitration section there. This would allow a recall dispute directly to go to court. A recall, for those of you that don't know, is an instance where you are removing a director before their term is up. The discussion around recall is basically it's the only way that you can remove a director absent, their resignation is by way of a member vote, whether it's through a signed petition or I believe it's HOAs only that can also try to have a meeting to vote them out. But it's the way to remove a director before their term is up. Board members, the board cannot remove their own directors. It can only be done by recall by the membership. So if there is a dispute regarding whether or not a recall is valid, now the parties have the ability to file suit instead of having to go through arbitration. Another big change, I think, is that owners may sue pre-suit mediation instead of arbitration for certain disputes. So for condominiums, if you ever had an issue over a use restriction, same thing for cooperatives. If you have an issue over a use restriction violation, you would have to send a pre-arbitration notice, and then you'd have to go to arbitration before the DBPR. And then you'd have an arbitrator assigned. It's kind of supposed to be like a less formal court proceeding. It's not as expansive in terms of discovery and what goes back and forth. The arbitrator kind of controls the process. But I think what we were finding is that arbitrators were kind of overworked and the cases were taking too long to resolve. For HOAs, you've already had the ability to go through pre-suit mediation, and that's been successful, I think, in resolving disputes. So now condominiums have the ability to do that. So if you had an owner with a use restriction violation, whether it's a pet violation, right? They have a pet that's over the weight limit. They don't otherwise qualify as emotional support animals or anything like that. Instead of having to send a pre-arbitration demand and then going to arbitration, you can send a pre-suit mediation demand, which basically says, we want to mediate this. We are offering to mediate, and in lieu of, because you can't yet proceed to court, but that if we do not resolve a mediation or if you don't engage in the process, then we can file a court action. So the fact that that's opened up for condominiums, I think it's going to be it's going to be great just to help further resolve disputes a little bit quicker. Mediation can be a little bit more expensive in some. I don't say more expensive than arbitration. It just depends on how long the arbitration process lasts and what the arbitrator requires. But mediation does involve, paying your attorney, splitting the cost of the mediator. But the benefit is that parties typically have a tendency to want to resolve the issue when they're sitting down. They're like, let's just get this figured out. And that I've seen that happen a lot of times with HOAs that I've represented, where even associations that I've represented, we've talked to them going into mediation and they'll say, I don't know how we're going to settle this because they need to do X, Y, and Z. And what happened? They reached an agreement that said, well, you need to do X, Y, and Z, but it needs to be at this date. And we're going to grant a variance on this issue. And then we've worked out our attorney fee issue. So I do think it's a good thing for condominiums that this has happened. And then this was kind of a clarification we've already interpreted because of the provisions in the Corporation Not-for-Profit Act. But it says board or committee members may participate remotely in meetings, including for quorum and voting purposes. So this much more clearly defines the ability to do that. All right, so I see we have some questions. I'll see if I can take some right here. All right, Lynn says, do you still have to have a board resolution passed regarding virtual meetings? Can they continue to go this way without special emergency powers? So that's a great question, Lynn. The answer that I've given is I feel comfortable with the board having completely virtual board meetings. I think there is some support when you look at the act regarding whether or not a physical location is required. It's just that there is a potential for risk that if a decision is made at a completely virtual meeting and somebody really wants to fight the association on it, that they may invalidate the action taken if it was found that there should have been a physical location and a method for people to participate in the discussion without having to use their own phone and dial in and so on. So when you can, I would recommend having a physical location where people can show up and maybe you have a speakerphone there or something like that. I know that's not always practical depending on the type of community that you're in, but I feel better about having completely virtual board meetings depending on the platform that you use, because so many of them like Zoom or Teams or whatever it is, that it's not only, you don't even necessarily have to have an internet connection, that even there's a dial-in number that you can use for it. And so, you know, while some people may have issues with internet access, although I don't know how that can be the case in this day and age, you know, it's almost like a necessary utility to have, but even without internet, you can still dial into it. So I think it's pretty easy for people to. So if a community, this is the real lawyer answer for you. If a community were to decide to continue to have completely virtual board meetings, I'd feel very comfortable defending that. But I would say still that in order to be completely airtight is to still have a physical location, even if it's just where you have a speakerphone set up for people to be able to go in person if they want to, without ever having to rely upon their own dial-in or internet or anything like that. But it's a great question. Howard wants to know, what does give notice by electronic means actually mean? If people have not opted in or you don't have emails, how do you accomplish this? Does it mean you can just post a notice on the HOA webpage? That's a great question, Howard. And that's only in emergency situations. So I think what is being contemplated is that if people aren't actually at the physical property where you normally would have to post notice of the meeting, that you provide notice as practical, whether people have opted in or by posting on the community website. And I think as long as you can show, again, this isn't an emergency situation, right? So the idea would be that if you're only doing it electronically that way, it's because you can't get to the physical property to actually post notice. And so as long as you can show that you sent it out, even if people didn't opt in, if you have their email address, I would say, look, this is an emergency notice. We're sending it to you because we have your email. It's not substituting them opting in for normal situations where you have to provide, you know, the opt-in to receive electronic notice. That should be enough. But if there's any questions about it at the time, you know, we're not in the emergency state right now, I would just make sure to get with legal counsel on it so that whether it's us or another lawyer can look at it to say, hey, we're only going to provide notice this way because we're in a community that people aren't here. It's been, you know, there's an evacuation order or something like that, right? I would just make sure to double check with legal counsel, but that's the way that I interpret it to mean. So Jeffrey asks a great question that we received. Can a board close off fitness centers, pools, et cetera, due to COVID? There's always going to be risk analysis with that too, both pro and con for it. The pro for doing it is because obviously our cases are on the rise right now. We're trying to limit the access, you know, or the instance for the potential for spread. The downside of doing it is that people are going to state that everything is open right now. There aren't any lockdowns in effect. I pay my assessments for amenity usage and I should be able to use it. There's no mask mandate in effect in Florida, at least right now. So you're going to have pros and cons for both of it. I think that if you, because of, and we're going to talk about House Bill 7 that passed regarding liability from related to COVID claims, that I think associations are in a better place to understand potential for liability right now than we were a year ago. And I'll talk about that a little bit more later. I think it's less likely that the association will be dragged into a claim on a COVID-related instance because of that bill being passed. So if you were to keep the fitness centers open, you know, one thing that you could continue to do, what we recommended previously was if for anything that's open that just says, look, you're using at your own risk, the association does not undertake to prevent the spread of COVID-19 and you're recommended to consult the advice from local, state, and federal, health and management officials, something like that, where you're just providing that disclaimer before people use anything. Mark asked a question about recall. It says each building in our association has one director, total of 5. So I think that means 5 buildings, 1 director from each. To recall a building director, is it the vote of that specific building only, or must it be an entire association member vote? So Mark, I think for that one, it would really depend on, I'd have to look at your governing documents. That's a more specific question, probably more related to your community rather than what the statute provides. So if you'd like, and if we do work for community, anyway, please feel free to reach out. We can see if we can help out with you on that, but it's not something I can really answer for the purposes of this seminar. Paul wants to know if mediation, if the opinion is or the decision is binding. That's a great question. If you do reach an agreement at mediation, what you then have is an agreement for one party or both parties to perform in some way, and that if they don't perform pursuant to that agreement, then you have the ability to go and enforce that agreement in front of a judge. So yes, that's the benefit of going to mediation, because a lot of times from the HOA standpoint, you're arguing over a violation of the governing documents. And if you weren't able to reach an agreement at mediation, you would still have to prove in front of the court or a jury, depending on what case you go, that a violation actually exists. If you go to mediation and reach an agreement where they say, yeah, we admit we shouldn't have done this and we're going to remove this by this date, you've already taken the proof that a violation existed off the table because they've already agreed to it. Now you're only arguing over whether or not they agreed with the term, or they satisfied the terms of the mediation agreement. So that's why it's so important and why it's so beneficial to go to mediation, that you can tie up some things, get the parties to agree to something, and now you've got something that you can enforce more easily. Zenzi says there are still so many venues that aren't allowing large groups. How do we go about finding a meeting space if we can't go completely virtual? I mean, it's a great question. There's no perfect answer there. I think as long as the association does, undertakes its best efforts to do that, and if it comes up where say, look, we've got such a large community that we can't have a completely, a physical location where people could show up if they wanted to, there is a process under 617, which is the corporation not-for-profit statute, that says that there is a way for shareholders to attend virtually or not in person. I forgot what the specific wording is, but there has to be a process to verify them in advance. And so there is a potential for I haven't really pushed that as much as being a way for the associations to go, just because it's not in the association specific statute. But if an association were to use that, I think we'd want to look at, all right, we're going to have a completely virtual membership meeting, and pursuant to 617, and I don't have the exact site for the statute in there, but there is a mention of what I've just said about shareholders attending virtually, that you need to have a process in advance where you're basically saying, all right, for us to count somebody present, we need them to register to tell us this is our email address and this is what we're going to use to register to attend, let's say on Zoom, for example, or if it's a phone number, that this is our phone number on file, so that when they dial in and they have the phone numbers lining up for attendees, that is their phone number. And then you're going to have to go through the meeting and say, here are our virtual attendees. We have them registered. It checks off with what they told us in advance, so that way we can deem them to be present. That is a potential way to have a completely virtual membership meeting. There's been some discussion and it hasn't been tested. But if the association is thinking about going completely virtual, you'd want to plan for that well in advance to make sure that you have a way to verify when people are joining in via Zoom or via Teams or dialing in, that you have a way to actually verify them. So that's a great question though, Zenzi. Let's see. Lynn says, let's see, a small community levied a huge special assessment, been doing meetings and such for over 2 years. Membership waive reserves every single year and no money. So the board levied the assessment. Now the membership's trying to fight the special assessment. Okay, and there's a petition around for a board recall. Building is in dire needs of repairs. Question is, can the membership actually recall the board to stop the contract? Okay, yeah. So I think the main question is, the board is trying to undertake a project. You've got members that are upset because it's resulting in a special assessment. If the special assessment is necessary, which is what it sounds like, can you use that as a way to prevent the recall? The answer is no. Members can recall for the directors for anything without having any reason stated for it. So if the recall is valid, then, that new board may attempt to stop the project. Certainly you have to look at what contracts are in place and what obligations the association may have, and really would strongly recommend talking with the association attorney on that. But no, you can't prevent a recall because of that project going on. It's as long as the recall is facially valid in terms of you have a majority of the members and they executed the petition properly, you're going to have to accept it. And then that board's going to be responsible for making sure that they administer the common areas properly and adhere to contracts entered into. But that's a good question on recalls, Lynn. Okay, so I will, there's a request. I'll hold off on taking some further questions until we get further along. I wanted to try to answer some of them as they came up on the slide. So if you have some, please feel free to put them in and I'll make sure to answer some later. All right. All right, so this was a change for condominiums. If an association's insurance policy does not provide subrogation rights against unit owners, then an association policy issued to a unit owner may not provide subrogation rights against an association. What that means is that, and we're just dealing with this with one community that I represent, an owner files, let's say an owner files a claim against their HO6 policy, which is the homeowner's policy that you have when you're in a condominium. Let's say that the carrier pays to that owner based upon some damage that occurred within the unit, but then the carrier believes that it was actually the association that was at fault. That carrier then would subrogate against the association and its carrier for, well, as long as the association reports it to its carrier, for reimbursement for amounts basically that were paid out underneath the underlying claim. The problem is that most associations policies do not have a right of subrogation against the unit owners, but owners policies have the right of subrogation, right? So you have this instance where basically there's a lot of them association owner claims coming back against the association. Then what happens? The association's having to file a claim with its carrier, whether or not it's a valid claim. But the reason why you have association is to provide defense against anything. And so maybe that's an instance where it was solely an owner responsibility. The association wasn't at fault, but now they have a claim still from the owner's carrier that we now have to respond to and either pay to defend or defer over to the association's carrier, which is then defending it. And then guess what happens? The more that they defend and have to pay out for legal costs or anything on the claim, the more that association premiums go up. So the idea from this is that this is going to help maybe stem a little bit the rise of condominium association insurance premiums, because it's going to prevent the ability for HO6 carriers to then make claims against the association under subrogation. The next part is that discriminatory provisions in the condominium documents may be removed without having a member vote. I like to say if you want to take a look at a condominium declaration that was drafted in the 70s, I think you'd be surprised by some of the language that was used in it. I've seen instances in the news recently, discussion of HOAs and certain use restrictions for covenants that were drafted, in a different time, and you'd be shocked as to what is included in who may or may not live in a community, for example, which obviously is, you don't even know how you even look at that in any other way of saying it's absolutely wrong. But the thought is that, well, but to remove that, even though we know it's not enforceable, and I've had to give opinions to clients that have certain language, not as bad as what I just mentioned, which was from another state, but certain language that might be deemed to be discriminatory, I could say, look, I know it's in your declaration, but that's not enforceable. This now at least allows you to even clean that up and remove that in the first place without having to have a membership vote. So if you're in a community, it's typically probably an older community that has certain language in there, you can go through and try to clean some of that up without actually having a membership vote. Now, certainly you're going to want to talk to legal counsel to make sure that you don't want to go so broad that this, that you're using that as a way to not have a member vote on something that does require it. So what I would recommend is getting with your legal counsel and say, hey, we think the following terms are discriminatory. We don't like that it's in our documents. We know it's not enforceable, but we'd rather just cut it out. Is this something that we can pass as a board? And that would be the way that I would do it. The other thing for condominiums, it says that in terms of official records, bids for work to be performed, materials or services must be maintained by the association for at least 1 year after receipt of the bid. There were some questions about that, and this clarifies that that is the time limit that you have to keep that. Regarding renters for condos, it said that Before, there actually said that you have the right to inspect the bylaws and the articles as a renter, but not the declaration. But the declaration really contains more of the things that renters would want to see in terms of what can they do with the unit. So it clarifies that you have the right to inspect the declaration and the bylaws as a renter, but nothing else. The association may not require an explanation or reason to inspect the official records. There have been arbitration decisions that have stated this, and that's always what we've advised associations where there's a question of, hey, can we make them state why they're asking for this before we provide the records? And I've always said, no, you can't. You have to make them available. It doesn't say they have to state a reason. Now it's specifically stated in the statute that you cannot require an explanation or reason before you allow inspection of the records. Associations may make records available through a mobile device app in lieu of posting on the website. So the statute up until now has provided that you can have physical copies of the records where they go and inspect the records in person, or you can put them on a website or some type of like a computer that they can access. You don't have to have a physical copy. In other words, this expands it to say that I think there is maybe a difference, but well, if we have an app on our phone, but we don't have an actual physical website to go to, is that going to be enough? And it says that a mobile device application in lieu of a website would be sufficient, that you can say, hey, everything is available on this app, download the app, and that would be sufficient for making the records available for inspection. And then this last bullet point, this is one where I mentioned that this is the third time that this has been discussed in probably 4 or 5 years. So it started by way of brief history lesson. It said that board members cannot serve more than 4 consecutive 2-year terms on the board. Then the question that came out of that was, when does that apply? Is it for, if now that the law is effective, I think it was July of 17, does that apply to every director that served 4 2-year terms up until now and that they have to drop off the board at the next meeting? And the other question was, what about 1-year terms? What if you serve 8 consecutive 1-year terms? And so then there was a change to it that says that it's an 8 consecutive year limit, regardless of whether it's a 2-year term or whatever the case may be. And then it further clarified that you could stay on the board, though you can, notwithstanding that, as long as you receive 2/3 of the votes at the election, or if there weren't more candidates and vacancies. So yes, you've served for at least 8 years, but you're only 1 of 5 for 5 spots, then there's no need for an election. That means you can still serve on the board. But it's still left open the question of, does this apply retroactively or not? And they've clarified it to state that it applies for years of service beginning of July of 18 going forward. So really, this is not going to be a problem or something that should come up until really 2026 is the way that we look at it. So this was a big change for condos. For the longest time, it's been that you could charge a transfer fee of $100. And that's in relation to the sale or the lease of the unit. But I have a reminder there that, just as a reminder for transfer fees, you can only charge a transfer fee in connection with the sale or lease if the association actually has approval power. If you just have a notification requirement, you don't really have the ability to charge a transfer fee. And there's been a lot of back and forth about this, just kind of similarly with the estoppel fee, that there's been an intent in the legislature to try to at least put a cap on when associations may charge fees in connection with the sale or the lease of a unit. So that's the first thing, is that when can you actually charge a transfer fee? And that's where I have that bullet point. Then the second point is that they did raise the transfer fee from $100 to $150, and that the DBPR may further increase every 5 years based upon the CPI. So at least those fees are able to be going up, but we've seen instances in different parts of the state where associations were charging $500 as a transfer fee. And it's one thing if management charges that back to the association, but it's always been that really typically that type of cost from a management company would be, the idea would be, is that would be collected from the owner. It's really a pass through. But to be able to charge that fee again, you have to have that authority in your declaration. For HOAs, it's different. There is no transfer fee cap in the HOA statute, but the advice that we've given is that if you're going to be able to charge a fee like that, it needs to be in your declaration. And so you would need to have a member vote to amend to add it to your declaration. The next one, it talks about natural gas and fuel vehicles have similar rights to electric vehicles in terms of stations. So the law changed, I want to say 3 years ago, regarding electric vehicle charging stations, where there's a process for an owner to request and have one installed for a parking space. They have to go through all the hoops of making sure that the plans are safe, that they pay for the increase in premium on the association's insurance policy, that they pay the electric charges, all that kind of stuff. But the idea was that the owner be responsible for it, but the board could approve it without having to have membership approval as a quote material alteration. They've expanded that this year to include not only electric vehicle charging stations, but natural gas stations, I guess, whatever that might be, and I'm not as familiar with that. I'm more familiar with the electric vehicle, but assuming obviously a more environmentally friendly, if there's a natural gas fuel vehicle that has a station that you need, it also falls in with that, where the board can approve of it as long as the owner meets all the requirements without otherwise having to have membership approval. Then the other one, it clarified that there's a 14-day notice requirement for all membership meetings if the bylaws do not specify a specific notice requirement. So most documents do provide for that, but there are some where there's a little bit of a loophole there. This closes that off to clarify that you need at least 14-day notice for all membership meetings. There are the conflict of interest provisions in 718.112.2p. It made it really difficult for associations where an officer or director entered into an agreement because of maybe some business interests that they may have in the association. It made it more difficult. They've eliminated some of that, but it doesn't remove the ability to allege a conflict of interest between the director and officer and the association. Like, for example, if a director has a financial interest in a vendor that's bidding, but then doesn't disclose that, participates in the discussion, and then votes in favor, there could be obviously a potential for violation there of a conflict of interest provision. There's a way for the director's business to be able to be considered, but that director needs to disclose it. They need to sit out from any type of discussion on it and so on. So it makes it a little bit easier. I guess the takeaway from this is that it does make it a little easier if there is for service providers, but there still needs to be the appropriate process for disclosing that and having that director and officer not participating in the vote on it for sure. The other thing too, from the fining process, and this was for HOAs as well, the statute was amended a couple of years ago to clarify that after the fining committee approves a fine, it used to be that the fine was due within 5 days of the hearing. But the problem was that a lot of communities say that, hey, we'll provide you with notice as to what the committee's decision was. And then they may have been providing that more than 5 days after the fact. So the fine is already past due. This clarifies that the fine is due within 5 days of providing the actual notice. And that's for condos, HOAs, and co-ops as well. All right, so going in on the HOA side, recall and election disputes may be filed for arbitration with the DBPR or court action. So similarly, and I say currently, but that was previously, I should say, you could only proceed to arbitration. Similarly for condos, associations may remove discriminatory restrictions from the governing documents without a member vote. The next one was a big one. This was, I could see, I said it, and Lee, if you remember me saying this when we taught the legal update, when this happened, that this was a big deal, especially for management companies. Previously, a couple of years ago, they put into effect that for any type of notice that was required under 720.306, which is the statute governing membership meetings. So you're talking about your member meetings or your elections, that the association would have to double check the property appraiser website to see if there's a different mailing address than what the actual property address is that's on file. And you'd have to then also send it to the property appraiser website. I know some of you in here are in communities, might be in a master association with more than 1,000 members. That's a huge burden to have to go through and track the property appraiser website for all 1,000 addresses to see if there's a different mailing address that the owner may not have provided you. This removed that. I think they realized how big of a problem it was. And it now defaults back to the association sends notice to the address on file. If it's, if all they have is the property address, that's fine. If they have an alternative mailing address, they'll send it there with a copy of the property address. But there's no obligation then for the association to double check to say, hey, did this owner update their address with us? We need to check the property appraiser. That's on the owner if they didn't update it with the association, which is good news. So another change too, this was, I don't know if it was anticipated when they did this at the time, but there was a change to the statute about maybe 4 or 5 years ago that included rules and regulations under the definition of a governing document, along with the declaration, articles, and bylaws. And the problem with that was that then the statute says that any amendments to governing documents as a defined term need to be recorded. So what we were telling associations was, hey, if you amend your rules and regulations as an HOA, because it's a governing document, you need to record those, which typically amendments to rules and regulations were not recorded. So this resulted in kind of a cumbersome process to have to do that. It's not free to record records. It's $10 for the first page, $8.50 for every page afterwards, plus any other stamps for that. So like from that standpoint, it will at least save it. And now you're not having to constantly stay on top. If you amend your rules a couple times, you're not having to always send them out for recording. The next one is that it clarifies that election documents must be maintained for 1 year after the date of the election, similar to what's been in place for the condos. So in terms of the envelopes, any proxies, the ballots, all of that needs to all be kept together and kept for at least a year after the date of that election. An association with more than 100 members may provide alternative notice of meeting by posting on the website or mobile device application. The board must adopt the rule with procedures before implementing. So take a look at that. Again, this kind of goes back to that question, though, I think from Howard regarding, the ability to have electronic notification of what if you don't opt into it. I would just double check with legal counsel even before this one, because this is an instance where there needs to be interpretation of whether or not you still also need to provide with physical posting on the property or not. So I would double check before solely trying to go with a meeting notice that's solely electronic. I put this one in here, and I'm not sure if one of our members that is attending right now, but this next bullet point it's for HOAs. It said records regarding security access, if it's in a gated, guarded community, are not considered open for inspection by the membership. They're still considered to be official records, but they're not open for inspection. I like, we're talking about the legislative session and the legislative process, and I love to brag on this for a client that we work with, a board member that reached out directly to one of the state senators during the legislative session to say, hey, this is a problem in our community. We think there's a privacy issue here. We've received an opinion from our attorney, which was us, that basically said, I think that it's an official record that's open for inspection because it's a written record regarding operation. That's kind of the catch-all for what's an official record. And so I believe the comment was, we don't think that this should be something that we should have to produce. We would request as part of the session, can we try to exclude that out? And I'm paraphrasing here. I'm not sure exactly what the discussion was, but I understand that to be probably what likely was similar to happen. And so this is the power of it. These state senators and the representatives that you have, they hear from lobbyists all the time, but when they hear from a constituent directly, they're going to take notice of that. And if they know that this is a problem in a community or something that's come up, and I can tell you it's been an issue that's come up in other communities I've represented, they're going to take notice. I understand in talking with one of the lobbyists, the senator said, hey, I heard from one of my constituents, I know you guys are working on this. Can you include this as part of your bill? And they said, that's an easy one, no problem. And so that's kind of how the sausage is made a little bit. But I say this, that if you have a big issue for your community, if something that you'd like to see change in the statute, never underestimate reaching directly out to your representative for your area. That gets directly to them, and they do listen. You are their boss. They will listen to you. They know that if they want to get reelected, they are in your hands. And so reach out to them directly, and this is proof that it can work. So I like to mention that. The other thing on this slide, it eliminates the requirement to maintain mandatory reserves established by the developer. So to kind of give a brief background for HOAs, there's 3 ways that you can have reserves in a community that we've always stated. It's if they are set up by the board because of authority that's provided in the governing documents, that's one way. The members can vote to establish reserves. And then the third way was the developer can establish reserves on their own, whether or not there's any requirement in the governing documents. And the law has always been that if the developer establishes reserves, then the association has to continue funding them, even if it's not something that's set forth in the documents. This now eliminates the requirement to maintain reserves that were established by the developer. So that's something that the association should look into. Obviously, you want to make a good business decision and say, well, hey, it looks like there was a reason for it, and it's been good that we've been funding it. But it does provide some more flexibility for the association when doing that. This is a change to a pretty big one, and one we've been talking to our clients about that we could see kind of coming down the pipeline for the last couple of years. The question that I've always received, and one of the biggest differences between condominiums and HOAs, is that for condominiums, if you're going to amend your condo declaration to restrict the ability for somebody to rent their unit, whether it's you're extending the rental period out, a minimum rental period, or capping the number of times they can rent in a year, even if that passes the requisite approval, if it's 2/3 of the entire membership, it still is only applicable to those who vote in favor and then future owners. So people that don't vote or vote no, they are not subject to that rental amendment in a condo until their unit is sold, and then their subsequent unit owners responsible and subject to it. For HOAs, even if you voted against it, if it received the requisite vote of the members, that amendment's going to be subject to that owner, even if they voted against it. That's been changed to basically make it more like the condo side, except for two instances. One is if you are putting, if you're restricting rentals of less than 6 months, or if you're prohibiting more than 3 rentals per year. So what you can see here is it's trying to, even if associations don't have any type of leasing restrictions, but want to get rid of like the VRBO, the Airbnb type rentals, if they went from no rental restrictions to a minimum 6-month rental period, if that passes, that will be applicable to everybody, not just those who vote in favor. Or similarly, if they just say, hey, you can't rent your unit or property more than 3 times in 1 year, if that passes, that's still applicable to everybody. So that's a little bit of a carve out and a difference from what the Condo Act provides. But an instance where I think a lot of associations that I've seen are going to have a problem with it is that if you try to put in a rental cap that says, hey, only 10% of the units or the properties may be rented in the community in 1 year, what you're effectively doing is prohibiting somebody's ability to rent if they are outside of that 10%. If they've all 10% have already been rented so far, then you're on a waiting list. You're prohibiting that owner's ability to rent. Therefore, even if the amendment passes, if that person didn't vote in favor of the amendment, they could still rent the property out, and they can do so until they sell their property. And then that owner is going to have to then check and see where they're at on the list, if they have the ability to do that or not. So that is a big difference now, and that HOA should be mindful of if they're trying to implement, like a 1-year minimum rental period. I just had one community that I worked with that was going towards a 7-month minimum rental period. And I said, you can do that, but if it passes, it only applies to those who vote in favor. Why don't you just make it a 6-month minimum rental period? It probably accomplishes the same thing, but it's subject to everyone. It's a lot easier from a record keeping standpoint. So be mindful of that. Certainly, if you're looking at rental restrictions, obviously you're probably going to be working with your legal counsel anyways, but you're going to want to craft it in a way to see what's the best way to make this apply to everyone when we do it. And then it talks about like the change of ownership. When it talks about, subsequent owner, it says that if it's if I owned a property and I transferred it into my trust where I'm the trustee, for example, that's not considered a change of ownership, that now the amendment's applicable to me. You're going to have to look at if there is a change of ownership. They have a definition for what that constitutes, but they do have that in the statute as well. All right, so that's what we have for Senate Bill 630. I'm going to take the time just to try to answer some of these questions before we go some of the other bills that are not going to take nearly as much time. Mitchell wanted to know, should we put a notice in the elevator and the laundry room door to use at their own risk while the COVID's on the rise? I don't think it hurts to do that. I think you want to word it appropriately that just says, use at your own risk. Please, we recommend that you follow the health directives and so on, but also make it clear we're not there. Association cannot be held responsible for what portions of the property that the owners are considering to use. For example, at the time last year, I was saying like, we're not walking around wiping down gates and handles and everything and buttons in the elevator. Obviously, that still is important from washing your hands and everything, but we've all kind of realized that it's more of an aerosol, type thing where the masks are the bigger discussion point and social distancing. But I don't think it hurts to put that type of disclaimer language in there. And I'll talk a little bit. The next slide is going to be, we're going to talk about liability for COVID claims. One question was, what's the difference between mediation and arbitration? That's a great question. Mediation is where the parties get together. They have a mediator that typically is experienced in the area of law that you're dealing with. So whenever I go, I try to find somebody that is experienced with, real property disputes, covenant disputes, HOA disputes. But their job is not to make a decision. Their job is to kind of go back and forth, help try to convey offers and talk to each side about the strengths and weaknesses of their case and help reach a resolution, but they don't make a decision. An arbitrator, on the other hand, is kind of like a judge where they make a determination at the end, and it can be final if either side doesn't file a trial de novo within 30 days after that. So arbitrator can make a decision that may be binding. Mediator doesn't make a decision. They just try to help the parties reach a resolution. Teresa wants to know about bids. Let me see what we have. Let's see here. So it's just the bids. It's not all of the proposed, it's just the bids themselves, even though, so the ones that weren't approved, like the ones that were approved in terms of the contract, that's an official record that's longer. But for the bids that weren't accepted, you only have to keep those for 1 year, if that makes sense. So you're not having to keep those for 7 years, even if you didn't accept the proposal. Should approved minutes, open board packet be included in the association website? So approved minutes, it depends on the type of community that you have. If you're in a condominium of more than 150 units, there actually is a requirement to have a lot of these official records on an actual website. If you don't have to have a website, should you have the approved minutes? First of all, I would probably do like a landing page and then have a login so that only people in your community with login access can view the official records. But I would keep minutes on there. A lot of times people request copies of minutes or inspection of minutes. And if you can just post those once they're approved to the website, you can, whenever there's a request made, say, hey, all this is available on the website. We have those already. So the question was, is a transfer fee the same as a capital contribution? The CC&R state that new buyers need to pay a capital contribution. It's 2 times of the current assessment fee. There is a difference between transfer fee and a capital contribution. There's been a lot of debate whether or not condos can charge a capital contribution fee. I think there's arguments for and against that. But in terms of in connection with the process of, a new owner or a renter coming in, that's more of a transfer fee in terms of the application and that sort of thing. I think most attorneys have honestly stated that you can't charge a capital contribution fee as a condo. It is common to have that in the covenants for HOAs. So I can't give you a definitive answer on that. But yes, there's typically a difference though between a transfer fee and a capital contribution fee. If you're in an HOA, you really want to make sure that you have the authority set forth as to what the amount is before you charge any of those. And then for condos, like I said, there's a statutory cap and a healthy debate. And most attorneys say that you cannot charge a capital contribution fee as a condo. Not to open a can of worms on that. I'm telling you, it's not settled. There's not like we have an arbitration or an appellate decision on it, but there's been a lot of debate on that over the years. The rules and regulation changes that are applicable to condos? No, that was only part of the HOA statute. There's a question of, is there a dollar amount of how much has to be in the reserves if you have to use a large amount of the existing monies? It's a good question. No, the only thing is that your reserves have to be fully funded by default in terms of what the annual budget is. The question is, how do you determine what's full funding? And that is more based upon a formula of the components you're reserving for, what the useful life is, what the remaining useful life is, and what the funding level is so that you can have the amounts available when needed. And that's usually done through a reserve study. But there is nothing that says that you have to maintain a minimum $50,000 in your reserve account. There's nothing like that in the statute. Holly wants to know what paragraph number in the statute covering the rentals for HOAs. Holly, if you send me an email, I can get that for you. I don't have it on the slide right now, but I can get that for you if you send me an email. I'll type my email address in the chat so everybody has it. I believe I have it at the end of the slide too. All right. In a condo association, can the management company charge additional fees to prospective purchasers for documentation, or is the 150 the max that can be charged? Yeah, so the ability for management to charge directly, it's one thing for management to have the ability to charge the association. They can contract for that. But in terms of that fee being passed to the owner, that's where the statutory limitations come in. So you can't, in my opinion, you can't have a management contract that says, with the association that says, hey, we charge a $500 transfer fee that we will charge directly to the owner. And that's not really a way of getting around the $150 max that's in the statute, because that's what a renter or a prospective owner can be charged. The management company is the agent of the associations. That's why it's all applicable. Helen says, we recently had a meeting to review 5 proposals from roofers and to vote on and approve one. We distributed the proposals to all members present in the site of transparency. Is this a requirement? No, it's not a requirement that you send those out. Those might be official records that members can inspect upon request, but there's nothing that requires you to do that, but it's certainly something that provides more transparency for the community. Howard wants to know, if can a capital contribution fee be required just by a board resolution, or must covenants be changed to include such a fee? So that's a good question. A board resolution typically means that you're adopting a rule or regulation. Typically, you have to look at what your rules and regulation, what your authority is to establish that rule, which is typically for administration of the common area or what you can or cannot do with your property or the common areas. We always have a hard time as a law firm saying that a board can establish a fee by way of a rule. Typically should be done by way of a covenant change in terms of, because that's an actual now covenant that goes with the property and obligation for payment there. So that's why I would recommend having that done by membership vote to amend the declaration rather than by a board resolution. Zenzi asks, what's your opinion on developers fully funding their reserves? Well, I would state that if there are mandatory reserves pursuant to the documents, that there is a requirement that you have to fully fund those. Again, there's some changes to it now in terms of what the developer has to do. But that can be kind of a business decision for the developer themselves with how when they turn over the community, understanding that when the audit's going to be performed, there's going to be some pushback regarding whether or not the reserves were fully funded. So, from that standpoint, if there's a specific question, and Zenzi, I know you can reach out to me if you have a question on something. I'm happy to help answer it because there are a couple changes here regarding it with developers with reserves. I'm happy to look at it, but the main change from a post-developer association standpoint is that sometimes associations looked at a budget that was adopted by the developer and said, boy, we got this reserve item, but it's not required in our declaration. Our members didn't vote for it. Do we have to really continue voting for or funding it? This gives them the ability to opt out of it. Whether or not developers have to keep funding or what they're required to do, it's a little bit more of an involved answer, Zenzi, but I'm happy to get with you if you want to reach out to me. All right, so we've got a couple more questions, but I want to make sure we get through some more of the bills, and then I'm happy to answer more questions at the end too. All right, so for House Bill 7, that was passed and was effective as of March 29th. It's regarding civil liability for damages related to COVID. It provides liability protections to corporations, not-for-profit, as defined in 617-01-401, and actually associations were specifically included. And what it does is it creates a bifurcated claims process where the initial stage is heard by the judge and the plaintiff, which is the party bringing the claim, must plead with particularity. So that's a different heightened pleading requirement than what is normally required in a civil case. They must submit an affidavit from a Florida licensed physician that the defendant, so in this case, it would be the association or the management company, caused COVID-19 related damages. And they must prove that the defendant did not make a good faith effort to substantially comply with the controlling health standards or guidance. So what this is all saying is that it's a very difficult hurdle for a plaintiff bringing a claim to be able to successfully get past that first process before they can continue on with their claim. They're going to need to have a Florida licensed physician say that it was the association or management that caused the COVID related damages. So in this case, them contracting COVID and then, whatever, they couldn't go to work or whatever the case may be, right? Most physicians are not going to be willing to do that. They're probably going to say something, look, if you went to the grocery store, you could have gotten it there unless you were there would be such an extreme example of how you could pinpoint that it was exactly the HOA. It's going to be difficult to get an affidavit. And then beyond that, being able to prove that we didn't substantially comply with the controlling health standards or guidance. So even by posting those signs where you can say, hey, recommend that you follow that, using the common area and the common elements at your own risk, that's why it's going to be so difficult for owners to be able to bring claims. I think that should provide a sigh of relief to associations and management, just because if a claim is brought, many associations don't have insurance for this. There's an exclusion a lot of times for pandemics. And I know that we looked into a lot of this, that there may be already an exclusion even before the pandemic happened for this type of coverage. So the fact that it's going to probably discourage suits from being filed, I think is a good thing. Certainly somebody's probably going to try to challenge this of whether or not this bill could be passed in the first place and what the governor pushed forward on it. But the fact that it's there is a good layer of protection for the association, for lack of a better term. All right, so Senate Bill 56, there was a lot of discussion on this, especially when I spoke with the good people over at Vesta regarding the collection process and how that should go on. It provides that if an association changes the method of delivery of invoices for assessments, that the association must provide the owner with written notice of the change of delivery method 30 days before the issuance of the actual invoice. And the owner must affirmatively acknowledge the change in delivery method before it can be implemented. What that affirmatively acknowledge means, we don't really know. So if you, this is where one of the things where they put that in place, but they don't give us detail that says, well, does that mean they, have to sign something and send it back to you? Can it be an email that comes back? So if you have a question on that, if you're going to be doing this, I again hate to say, I promise I'm not trying to plug the legal profession, but I would talk with your attorney, because what you don't want to have happen is not comply with the statute, change it up. The owner for somehow doesn't receive it. They don't pay their assessments. We get into a collection case, and now they come back and say, hey, show me where you gave me 30 days notice of your change and how the invoices are going to be delivered. And then show me where I affirmatively acknowledge that, right? If we don't have that, that might affect the validity of the entire collection case. So again, I would talk with your management company. This is more of a management type issue in terms of, because they're the ones that are reaching out to the owners regarding this, but make sure that you have that. And if you have any questions, get with your legal counsel, provide an opinion on it. This next one is that the association must provide an owner with a 30-day late notice before attorney's fees can be assessed to an account. It includes the proposed form notice that must be substantially complied with in the statute. So where this came about was the sponsor for this bill, I believe received some type of an attorney letter saying that they owed back due assessments and they had attorney's fees attached. And that whoever it was basically said, I didn't even know I was delinquent because they never gave me a coupon book. And that may also have been a part of the change for the method of delivery for invoices for assessments. And so they basically said, look, before you can charge me attorney's fees, you have to send out a 30-day notice, and you have to document, and there's a rebuttable presumption that the notice was properly sent 30 days by executing some type of an affidavit. And so what they want to have is a specific 30-day notice that goes out before you can charge attorney's fees. So what this is really doing is kind of adding another formal step before an intent to lien letter can be sent out if you're using an attorney to send out an intent to lien letter. So spoken with Vesta, they were really on top of it, honestly, well before some other management companies that I work with, in terms of, hey, this is something we really need to comply with. We understand that if we don't send this 30-day notice, it could affect the collection effort down the line, because they could say, where was this 30-day notice provided? And if we don't do it properly, that could affect the case. So again, kudos to Vesta and for doing that, because it is a requirement. I've talked with them about, when you should execute the affidavit and so on. So, but that is a requirement now. And so, and for our law firm, we're contacted all the time, daily, from our clients and through management, basically saying, hey, can you all send out a letter to this owner? They're delinquent. They need to go to the next step in the attorney status. What we're asking for now, in addition to the ledger, whether or not there's a renter, whether or not they've been in bankruptcy, is, can you give us a copy of the 30-day letter that you sent out? So that's all part of the process now. The other thing for condominiums is that it changed. For an intent to lien letter, you'd have to give 30-day notice before the claim of lien is recorded. And then after the claim of lien was recorded, you have to give 30-day notice before you can file a lawsuit to foreclose if you want to get your attorney's fees. This now brings it in line with what HOAs have to do, which is it's a 45-day notice, then a claim of lien, and then another 45-day notice. My only thing with this now is that between the first sending of the intent to lien letter versus when the association is going to be able to foreclose, it extends that effectively from 60 days to 90 days when you're combining the two time periods. And really, you have to add some overlap time between getting the lien recorded and then getting the next notice out. But it just adds another month at least to the collection process. And so if you're in a condominium, I'd strongly recommend that you have a good collection policy in place, have a defined time for when that 30-day notice goes out before the attorney's fees start, when the intent to lien letter goes out, and then what the process is from there. It's going to really help you with your collection process, help your management company out, your AR person with management, and then help your attorney out, because we know that it's going to be a step-by-step process. The board's already approved, and then we typically then go back to the board at a certain point, depending on what the collection policy states. Usually it's after the lien's recorded and after the intent to foreclose letter is sent. And then we get back with the board and say, we followed your policy all the way up to this time. Now we're at the point where we need to file a lawsuit. But having that on a kind of a scheduled basis is going to make things a lot easier for you and make sure that you're being consistent with your collection process. All right, so Senate Bill 1966, this is really kind of like the DBPR bill. One big thing for and this really only affects condominiums, it replaces the term monetary obligation with the term assessments when you're looking at the delinquency of a member wishing to run for the board. So when you're running for the board, your eligibility is determined at the time that you put in your notice of intent to run. And it would state, though, that any director that is 90 days delinquent in a monetary obligation and also has to exceed, it has to be at least $1,000 or more, is not eligible to run. But monetary obligation could include a fine. And so what I think probably happened was, because fining is a more subjective process than passing assessments and assessments not being paid, is that communities may have been targeting people to make sure to prevent people from running for the board by passing fines, and that they could then preclude them from getting on the ballot. So this now says that it's delinquent of an assessment, not a monetary obligation, that prevents you from running from the board. The other thing that it says is that for condominiums, it says that the annual budget must be presented to the members no later than 14 days before the beginning of the fiscal year. There's a penalty for this if you don't do it after, I believe, a second attempt, that they can be subject to a fine if somebody were to file a complaint with the DBPR. It also states that if you don't provide it, that the previous year's budget goes into effect. All right, and then the last bill that I'm going to be talking about, and then I'll take some questions, is Senate Bill 76 regarding property insurance. So I talked about before about the right of subrogation and limiting that down. If the association has a waiver of right of subrogation, then that also means that the owner policies have that. And the intent is to try to lower condominium premiums to try to reduce the number of claims filed. The other thing that affects premiums for associations, whether it's a condominium or an HOA, are just the number of claims filed for property damage. And what we've seen is that we've had in Northeast Florida, we had Hurricane Matthew, Hurricane Irma in 16 and 17. A lot of claims were filed, especially after Matthew, because that was the first big storm that we've had up here in Northeast Florida for a while, that you had a lot of contractors that came in, filed claims through assignment of benefits. A lot of illegitimate claims were filed, a lot of promises being made. And so what happens is every time those claims are filed, a lot of times carriers settle just out of nuisance, even if it's a bogus claim. But all of that adds up. The number of claims filed and the number of amounts paid out on these claims leads to what's the industry going to do? They have to pay for that somehow. They're going to raise premiums for everyone. And so the idea is to try to cut down on that, is to try to cut down on some frivolous claims. So they reduce the time period for bringing a claim from 3 years to 2 years. I think what they found is that anything filed after the 2-year mark is more likely to be a more, skeptical, dodgy claim. So from that standpoint, they wanted to reduce it down from 3 years to 2 years. Certainly, if you do have a legitimate claim from a storm event, you're going to know it right away, and you're going to want to get people involved to get that claim going. So if you have the money to do the repairs, or if you're having to take out a loan, that you know that the money's coming in shortly afterwards because you've resolved it with your carrier. So it goes from a 3-year to a 2-year time period. It also establishes a mandatory pre-suit notice requirement for claims not brought through an assignment of benefits, which has its own notice requirement for it. You have to provide at least 10 business days prior to filing suit, and that does toll the statute of limitations that would otherwise run. Must include the alleged acts or omissions, the damages in dispute, the demand, and then any reasonable attorney and necessary attorney's fees incurred by the claimant. And that pre-suit notice is admissible, so you could show that you provided that to the carrier. The idea is, before you just go off and file suit, that you have to give them notice and opportunity, put the amounts in there, what you're asking for, and what reasonable attorney's fees you're asking for, before you can just go and just file off a lawsuit. They did also change the prevailing party attorney's fees. It used to be Florida was such a one-way state on this that even if you recovered a penny more than what the carrier offered, you'd get all of your attorney's fees covered. In this case, they do look at what percentage you recover either below or above what the carrier offered in terms of the ability to collect attorney's fees. So it's not as much of a slam dunk now that you're going to get your attorney's fees in a case. So what the whole intent is, trying to discourage all of these lawsuits being filed, because the thinking is that we're always going to get our attorney's fees paid, and really trying to have a more meaningful negotiation with the lender or with the carrier. Now, that being said, if you've got $1 million loss and the carrier is offering you $500,000 and you've got a $500,000 difference, you absolutely should bring that claim, right? If you've got your evidence to back it up, you're going to get your attorney's fees paid for. But they're trying to limit it down for the more frivolous claims, and that's the main thing for it. So we're in hurricane season right now. Obviously, we're watching the tropics, and it looks like maybe, I think it's Fred, if I remember right, is probably going to go west of us if you're in Northeast Florida here. But be mindful of what insurance you have, the claims process. I teach a whole separate class that I'm happy to, if anybody would like to reach out to us about, before and after a claim event. But there are some changes as to how the process works afterwards that you really need to be aware of. All right, so I'm going to go, I'm going to keep this slide up here that's got my contact information, but we have some questions here. Let's see, Teresa says money is received from the current developer to repair the broken sidewalk and the backyard trees cutting due to trees are too close to the building. Should that lump sum be put in operating or reserve? If you're going to be doing the work, you can likely just put it into operating, because that, if you're going to undertake the work, if it's that's something that is going to be done down the line and you're already reserving for it, you should probably put it in reserve accounts. But that sounds to me more like a operating issue if you're going to start using those right away to cover those repairs. One question was, are you required to now have a board meeting to approve an ARC? This would be for an HOA community of 8 townhome owners. So that would just be dependent upon what your governing documents provide. If you're saying that you have a board, but you want to have an architectural review committee, just look at what your documents provide. It's not uncommon for a small community like that to just have the board be the ARC, in which case you're kind of having 2 different names. But if you do have somebody that's not on the board that you want to have serve on it, just follow your documents as to how that should be done. But typically you're going to be approving committees at a meeting, so it's reflected in the minutes. And that way, if anybody questions the legitimacy of that committee later, you can show, no, here's where the board approved it and it was within authority pursuant to our governing documents. Howard had a follow-up on the capital contribution fee. If it's not by board resolution, could it be in a bylaw change rather than a covenant change? Again, I think it looks like for bylaws typically are there for the purposes of administrating, like how the association operates from a corporate standpoint. So you're talking about the number of directors, meeting notice requirements, and so on. If you're trying to charge a fee, I know I get the reasoning for it, but if it's because you're trying to do it by board vote rather than by member vote, there's always going to be that argument that somebody's going to say that in order to charge a fee, that's a covenant, that's a use restriction that should be contained in our governing documents through our declaration, and that doesn't fit within anything in the bylaws that the board should have the ability to adopt. It's possible that you could do it if there's no conflict. I just would be hesitant to do that as a bylaw change rather than a declaration change. When I'm using the word condos versus townhomes, it's a great question. And so when I was talking about that, typically when I say townhomes though, townhomes are typically covered under the HOA Act. Now, there are some communities that are condos that call themselves towns, so it can be confusing. You do need to look at your governing documents. Typically, though, townhome communities are HOAs, which are homeowners associations under Chapter 720. Oh yeah, the question is, can the presentation slides be made available to attendees? Absolutely. Send me an email. I'm happy to send that out to you. And I know I'll make the recording available to Vesta and they can provide notice that it's going to be available. So no problem there. Alvin says that our board created a cash slush fund. Is that okay? You know, I think the idea is that's kind of like a rainy day or emergency fund. You know, typically you want to be able to budget for what is a known expense. You could possibly have an emergency expense there, but then you come into a surplus issue at the end of the year. I know communities do that. Maybe what you just want to create is some type of a general reserve account and maybe try to define it in a limited basis by saying it's for unanticipated capital expenditures or repairs exceeding X number of dollars, and then you just kind of fund that, and that might be your cash slush fund, for example. That way it's kind of got a broad usage, but at least it's shown that that's why that reserve account, that you're not touching it through your operating account. There's a question, and this might be beyond Teresa for the scope of this presentation. There was a condo unit that was built in 2020, closed, and when does the developer warranty start? Typically, the warranty starts from the sale, but there's also a different warranty in terms of the statute of limitations for any claims against the developer that the association may have that really runs from turnover. So that's just going to depend on your community, but that's kind of beyond the scope we have here. It might be more specific and having a look at what your purchase and sale agreement provides. Paul asks, is there a website to obtain updated Florida Statute 718? Yes, there's a way to look for it, but I need to check and see. Let's see here. I have to provide up, if you look for it, you have to look on the top and it'll say if it says 2020 or 2021 yet. I'm not sure if they've formally updated it yet to 2021 that implements all these changes. So you need to keep an eye out for that. But what you can do for any of these bills that we've mentioned, if you go and look up those bills, you can find the bill and then the actual bill text, which will include the statutory change with the strike through and underline. And that's a good way to see what the actual text is until the statute is actually updated, that you can find it more easily online. Helen says that no one in our 76 unit townhome unit is willing to serve on the finding or compliance committee. And obviously a director or an officer or spouse cannot serve. We're stuck. Is there any way around this? That's a good question. It doesn't mean you can't enforce your documents. It just means that you're not going to be able to go the finding route. So if there is a violation and you don't have a finding procedure in place, then you're going to have to go through the pre-suit mediation process as an HOA. And so that would be the way to do it. Of course, you want to try to have people, because finding can be a way to prevent going to that step of getting the attorney involved. But just because you don't have that committee in place doesn't mean that you're not going to have the ability to enforce your documents. All right. Well, somebody says informative webinar. Thank you very much. I appreciate that. Teresa says if there's a construction defect and developer warranty class in the future, I do have that class. If there's some interest in it, and Lee, I'm happy to talk with you if that might be something we might want to teach separately. I can certainly do that. That's no problem. All right. Well, Lee, that's what I have. I know we had talked about, if anybody is interested, we could talk about with some of the issues and what we see maybe happening in the future. If you want to have that discussion of what, I think we're going to have another active legislative session in the future. But and that's largely because of the Surfside collapse, down in South Florida. I think we're going to see some stuff come out of it. But Lee, do you have anything that you want to add that I didn't touch on, or have any other further discussion on it?
No, I don't think so. You covered everything, and I agree with Ed. I think the 2022 legislative session is going to be as active, if not more so, than 2021, especially with the COVID situation continuing as it has, and then the situation down in South Florida, the horrific situation down in South Florida. As always, Vesta will certainly do our best to bring you updates and information as it becomes available to us. We partner up with McCabe Ronsman often on these educational seminars, and it's always our pleasure to do so. We thank all of you for your time this morning on a Friday morning.
Yep.
And we'll be doing a board certification class prior to the end of the year. If you do have some specialty items such as the construction defect or other similar type of informational rules and regulations enforcement, I know there was an issue about fine committees and things like that. Ed and his firm can offer those types of seminars, and we can support that for you. So I just want to thank you, Ed, for your time as always. And thanks to all the board members and committee members and CAMs that are out there. Make sure that you get your license numbers in so that you can get your CEUs. And other than that, happy Friday, and I hope everybody has a great weekend.
Great. Thanks, Lee. Thanks, everyone.
All right. Bye-bye.
Bye-bye.